you can remember that as you give us your presentation. We've also conferenced the case before coming in this morning. As you may be aware, we are now videotaping our oral arguments and making them publicly available. So for those who may choose to view the tapes, if you'd do us the courtesy of announcing both your name and that of the client you represent when you begin, we'd appreciate it. Each side will have 20 minutes for oral argument, and the appellant is responsible for watching time. You may save as much time as you like or are able for a rebuttal, and with that, we may begin.
Thank you, Judge Swan. My name is Charles Railing. I'm the attorney for the petitioners. I represent the employer in this case, Crescent Crown Distributing. I should point out that the captioning on the brief demonstrates a change of carriers from when the case was litigated. It indicates Twin City Fire Insurance care of Sedgwick. It was the Hartford. There was a change in carriers which assumed coverage under the claim.
So should we show Hartford then on the caption instead of Twin City?
No, Your Honor. It's
the reverse.
Should remain as captioned. Correct.
I see. Okay.
Just wanted the court to understand that there were discussions between the judge and the parties regarding her involvement with the Hartford claim.
Thank you.
It's the position of the petitioners that the decision of Judge Nye is not reasonably supported by the law and the evidence. We have essentially three arguments that we set forth on our opening brief. The first is that the testimony of Mr. Ketterling does not support a specific injury occurring by any positive proof on March 27, 2012 in the course of his employment with the respondent or petitioner employer rather.
Define positive proof for me.
Some evidence that it happened as opposed to a statistical or probability theory. He admits that he did not see a scratch until 8 days later. His entire claim is based 100% on his statement that he frequently sustains scratches at his 6 different stores where he works his route, and that this store, because of its closer aisles and so forth and large beer load, increases that statistical probability that he could sustain a scratch. He presented no evidence that he scratched himself at that Bash's store at 7th Avenue and Osborne, and admitted that clearly in his testimony.
Does it matter whether it's Bash's or Fry's or Safeway? Isn't the real issue whether he sustained a on-the-job or work-related injury here, a scratch that would have allowed the bacteria to cause this serious infection?
Absolutely, Judge.
Okay, so he testified, as I have reviewed the record, that the only place, this was a question, the only place that you could have obtained an insect bite, a bump, a scrape, or an abrasion would have been at work. His answer was yes. Could not have occurred anywhere else in your normal life, busy life, question mark? Answer, no. Banged it on a coffee table? No. So with all that evidence, he's pretty definite that this had to have happened at work.
There are a couple answers to
Okay.
that. The first is, he claims he was injured on March 27, 2012. There is no specific statement in what Your Honor just read that he could not have been injured in those ways. I woke up with a bloody forehead this morning. If anybody wants to tell me how that happened. It's not within the realm of normal human experience or believability. That isn't a credibility issue, that people don't sustain unknown scratches. And as a matter of fact, that's what both of the doctors indicated. All it takes to create this problem, because the strep A is on your skin, is a microscopic portal of entry into the skin. It can be from an insect bite, a scratch, bumping yourself, anything that allows intrusion of the staph that's already there. It's an endemic situation. Both of the doctors indicated, even Dr. Pham, whose testimony that was relied upon by Judge Nye, after being told to assume as a hypothetical that he scratched his leg, his left shin, on March 27, 2012, Dr. Pham provided reasonable medical probability when he was forced to beg the question. But he then backed off immediately. He took a step back and said, I can't tell you when. Dr. Kelly said the same thing. He was actually asked that same question by counsel for respondent, and he said, I can't ascribe reasonable medical probability based upon the facts as I know them, because these ways of incurring scratches or bruises or tears in your skin are so infinite. We don't know when they happen.
But what physician could be expected to offer that kind of testimony?
That's
They
our
weren't
point.
there.
There has to be specificity. If you have a dirty wound at work that's documented, it becomes infected. For you to sit back and say 8 days later, I'm going to now create a claim based upon the fact that I've obtained scratches on my shins at work in the past without any further documentation.
I guess my
that-
question's a little different. You seem to be saying that we should doubt the causation here because the doctors couldn't testify that it exists. I'm suggesting that may be the wrong place to look, because by their very nature, the doctors wouldn't be in possession of that information. If the ALJ finds Mr. Ketterling credible, isn't that
No.
sufficient?
Well-
And given our standard of review, isn't everything else just an argument about weight?
Credible as to what, Your Honor? All Mr. Ketterling told us is that he regularly sustained scratches on his shins. There's no evidence that he scratched it on March 27, 2012. That was his claim. We
Is there
pointed
any
that out
evidence that he
forcefully.
had to have?
I'm sorry?
Is there evidence that he had to have? What if it happened on March 26th?
Well, the injury's March 27, 2012. That's the claim he filed. And we argued that in the opening brief. That's the claim he filed.
That may be when the injury manifested, but was there medical testimony to suggest that the injury was necessarily tied to an event that can be measured down to the hour or the day?
This wasn't a
Question whether it manifested.
It didn't manifest until April 4.
Right.
The date that Mr. Ketterling picked was March 27 because that's the date he worked at the Bash's store at 7th Avenue and Osborne.
But
Okay.
is that correct, or didn't he, I mean, Dr. Pham addressed the fact that there was somewhere between, I think he said, a 3, 5, or 10-day window when this would have occurred and the infection would have begun. So really, there's a 10-day window, and rather than you saying isolating it to the 27th, didn't he say that during this during this defined period that Dr. Pham addresses, this is the only thing I did where I could have been scratched? Wasn't that his approach?
Yes, but that's not the claim, Your Honor, with all due respect. When you file a claim and go to hearing and litigate March 27, 2012, you don't get bailed out by your doctor later. What happened in this case is that Mr. Ketterling sat down with the wisdom of hindsight and tried to prove a statistical probability case by reconstructing his work activities. He went to an urgent care, no history of an injury. Then he goes to the hospital, and it says that he bumped his leg on a keg, where I have the most likely possibility of scratching my shins. That's the extent of his proof. There's no specific proof of any scratch occurring at any time within the 10-day period of time. All he does know is that 8 days after the date that he is alleged as his injury, April 4, 2012, he notices redness on a scratch and seeks treatment at an urgent care center. That's where we think there's lack of specificity. Now,
Scroll back for a second and let's look at what we have here. We have a person who works for a company, and in the course and scope of his job, he testified and his co-workers testified that they get so minor abrasions, scratches, bumps, and this is a normal everyday occurrence, and they don't report it for purposes of workers' compensation because they're so minor. Now, that's what I understand the testimony. He testifies that a couple days after the 27th, he starts feeling kind of poorly, and fever, doesn't feel very good. And so that's kind of, that evidence is consistent with the doctor's testimony of the gestation period of this type of infection. Now, as I understand your argument, is that you would want him to say on such and such a day, March the 27th, at 2:30 in the afternoon, I sustained a scratch. Given his job and given how he described it as confirmed by his co-workers, that seems like an impossibility. You're putting him to an impossible standard. He testified that this is work. I get these type of abrasions and scratches at work. I don't get them at home. I don't get them at the golf course. I don't get them on the coffee table or get caught up by a cactus thorn, as he's asking the case. what would you have him show other than dates and time specific? And I don't know of a case that requires that level of specificity.
Well, it does in the Valley Fever cases, Your Honor.
But, excuse me, the Valley Fever cases are really distinguishable because there you have people, the Valley Fever spore affects everyone. Not everyone goes to a Bash's or a Fry's and stocks beer and liquor. We don't all do that. So the Valley Fever cases are really distinguishable because there the infecting agent can affect everyone in the valley versus what this fellow was doing.
Your Honor,
So do you have anything better than the Valley Fever cases?
well, let's talk about this case. Your Honor made
Now,
the
did you have any authority, other than the Valley Fever case or the Valley Fever cases, that you believe supports the level of specificity that you think he needed to show? Because if you do, I will go back, and I promise you I'll go back and read it.
Well, we cited the Yates case, Your Honor, in
Okay.
which the lady alleged a prick to her finger and later developed bacterial endocarditis, but the prick to the finger was an accepted responsibility. It has been Hornbook law for as long as I've been doing this that you must prove that you injured yourself as alleged, not to produce some statistical probability theory that that's how it must have happened with the wisdom of hindsight. He's also contradicted in the records at every step of the way regarding how and when this injury occurred. But back to
Is
what you
that-
said, it's not an occupational risk that if you work as a beer distributor that you get a bunch of scratches on your shins. That's not an occupational disease. He merely gets some scratches, and the occurrence of that with the strep A bacteria on the skin is the key to this case. It is a throwout, in our opinion, that there's a supposed exclusion of any other cause. That's not even within the realm of scientific possibility or human experience to say it couldn't have happened any other way. He doesn't know how this scratch occurred, and that's admitted.
Sounds like you're arguing that there's a threshold, it's sort of a de minimis threshold, and if an injury isn't important enough to document, if it later develops serious complications, it's just not compensable. So the standard for all employees should be document every scratch.
No, the standard is when the risk of an injury is so ubiquitous. There are people who suffer these necrotizing fasciitis cases without ever knowing that they've been scratched. Both doctors said that. The standard that the judge imposed, I think, is really interesting. If you look in finding number 7, here's where she went wrong. Dr. Pham thought, if his testimony was found credible, that in the absence of knowing of any minor trauma to the left shin from other causes, that it is likely a work scratch, abrasion, or cut that led to the development of his infection. That reverses the order of proof. In other words, the judge is saying that the defendants had to come up with positive proof that it happened somewhere else.
The judge said that. I think the judge endorsed Mr. Ketterling's own process of elimination, which is a different point. You may object to that as well as a method of proof, but that's not burden shifting.
We would ask that the court review the testimony of the doctors pertaining to how easy it is to sustain these scratches and the fact that it can happen, in the words of Dr. Pham, anytime, any place, under any circumstances. We quoted that in the brief. If this court finds that Mr. Ketterling's statement is necessarily credible, that it couldn't have happened anywhere else.
We don't make those findings.
Okay.
The
If-
ALJ does.
Well, I don't think the ALJ can, because that's against medical science. That's usurping her
ALJ
province.
the ALJ found Mr. Ketterling's testimony factually credible.
Yeah,
That's what the ALJ does. That's not what we do.
all that the ALJ found was that all that she could find was that he sustains scratches on his legs, on his shins at work. That's what he testified to. He did not testify that he sustained this specific scratch. He doesn't know where he got it, and he can't say he got it on March 27, 2012. That's what he had to prove. To say now, after the fact, that there was a different claim that we were supposed to be defending isn't fair. He got on the stand that day after we deposed him and said, I picked March 27. That's the date of my injury. That's the date I scratched my shins. That's the date the judge found in her decision. And nobody argued about that against us in the answering brief.
So if hypothetically he had gone to the hearing and testified, I just remembered there was a really bad scratch on March 26th, would you have objected that you didn't have fair notice?
Well,
I mean, I don't know what sort of preparation you would have done to prepare for March 26th versus March 27th.
Well, I would have been able to ask him if he reported anything to coworkers, which I did, and he said he didn't, even
Right.
his co-employee.
That gets back to my de minimis question.
Well, it's not de minimis. I mean, if he knew that he had an injury at that time and didn't report it, we would have had an affirmative defense of the failure to report your injury forthwith.
Well, he clearly didn't report, I mean, we know he didn't report, right?
He didn't. He reported that he was sick to a supervisor within 3 or 4 days from the flu-like symptoms.
Right, but he didn't report anything on the
understand.
27th.
He didn't understand the causal relationship until at least April 4, perhaps April 5, so he couldn't have reported anything.
Precisely.
But-
So I'm, and given all that you've just said, I strain to find the importance of the 27th, except as a pleading formality.
It was our entire case. We
Well, I
demonstrated.
get that.
Mr. Ketterling admitted in his deposition that he didn't know when it happened, but he was picking March 27, 2012. The doctors presented evidence based upon that theory. That's the theory that we presented, a specific injury, and defended against that specific injury. We would have introduced different proof, perhaps, as Your Honor has suggested, regarding how ubiquitous these scratches were. The co-employees testified, yeah, we get scratches. We didn't discuss all of the reporting in any great detail, but we're missing the point. The point on this case is that the judge couldn't find, based on the evidence presented, that there was an injury on March 27, so she adopted a legal theory of causation that, based on the totality of the circumstances and the preponderance of the evidence. When I lecture people on totality of the circumstances, my clients, I say, hold on to your pocket, because it means that the lawyer can't tell you all the different factors that are going to be taken into consideration. That's not fair to us. My client didn't think this was a fair decision because there was absolutely no analysis or proof of an injury on March 27, 2012, as alleged, nor at any other specific date within the 10-day
It's not
period.
advantageous to you, but I'm not sure that it's not fair, given the purpose of the Workers' Compensation Act. I mean, the proof requirements that you're advocating are certainly advantageous to the carrier, but I'm not finding them in the law. And Judge Norris asked you for authority on this. I guess I repeat the question.
Well, as I stated, Yates is one case that was cited. The case law is hornbook that the applicant has, I mean, from Reynolds to Helmerichs to, I mean, I can name a dozen of them off the top of my head, basic ancient case law that talks about the obligation and burden of the applicant to prove each and every element of her claim or his claim, and that the defendants don't have to disprove that. What the judge says, if you can't come up with a specific injury, I'm going to accept his testimony that it must have happened to work based on a greater statistical probability.
I don't think anybody's disputing that the claimant has the burden of proving the elements. The question goes more to the manner of proof, and you seem to be suggesting that there is a specificity requirement that I'm not finding. That's really where the discussion is focused.
Well, we raised that in the opening brief. We presented that injury date as our defense. There is no discussion in the answering brief whatsoever that this could be a gradual injury or an aggravation of a pre-existing condition. Mr. Ketterling is the one who came up with this idea. This is where it happened and when, March 27, 2012 at the Bash's store. That's the theory that he came up with to try to prove this case. When you look at Dr. Pham's testimony in closing here, I'm running out of time, his testimony is equivocal. When you read his testimony carefully and go through the different stages, I quoted on pages 8 through 9, the entirety of his testimony that was adopted by the judge. And what he concludes is that he says, I do not know when, but he had one of those. Well, clearly he had one of those. That was an infection. We concede that he had an infection. And he says, and it is very probable to lead to one of these infections. Well, he was asked to assume that he scratched himself on March 27, 2012. And he then backs off and says, I do not know when. I'm sorry, but that doesn't prove, it doesn't answer the question. Equivocal testimony, by definition, is when the doctor backs off of his decision and will not stick to the answer that he gave.
Here's I think my quandary. It seems to me that this whole case turns on whether Mr. Kettering was credible, and whether he presented sufficient evidence, as you've argued, that he sustained a work-related abrasion or an abrasion at work on the 27th. If he did, then the medical testimony is pretty consistent that skin opening, skin wound, infection, end result, serious infection. So it all comes back to him. It all comes back to Kettering, it seems to me. And the ALJ found him credible based on his testimony that he gets abrasions on his shins or on his knees, and they happen at work. They don't happen elsewhere. They happen at work. It comes back to him. Doesn't it? Doesn't this whole case resolve on his testimony?
It would, and yes, but the point is he never said that he got hurt on March 27. He never said he sustained this specific scratch at work. All he knows is he noticed it on April 4. He can't trace it back to anything happening at work. We think it's a throwaway fact. His assertion it couldn't have happened anywhere else, that's nonsense. Thank you. Any other questions?
Thank you.
Thanks, Judge.
Do I just start?
Go ahead.
Okay. May it please the court, my name is Brianna Chua with Taylor and Associates, and I represent the respondent, Mr. Ty Ketterling. The burden of proof in a workers' compensation case is preponderance of the evidence, more likely than not, more probably than not, and this is not a criminal case. We don't have to prove beyond a reasonable doubt down at the Industrial Commission. The petitioners argue that Mr. Ketterling should have to provide proof to the exclusion of any doubt, whether reasonable or unreasonable, and that's simply not Mr. Ketterling's burden. Mr. Ketterling was asked on cross-exam various questions. Did he hit the left shin on a coffee table? Could he have hurt his leg on with a cactus thorn? Was he working out? Did he get the scratch working as an equipment manager at the time? And to all those questions, the answer was in the negative. It was no. The only evidence was that of Mr. Ketterling's testimony that he sustained the scratch at work, and then that scratch then later became infected. Speculation and conjecture, skepticism, not rooted in the record, will not support an award, and that's under Hackworth. He wore shorts to work in his usual course of employment. He would sustain these scratches regularly. He didn't think they were a big deal. That's consistent with Amanda Pena and his partner, Luis Ramirez. They did not report them, and under Douglas Auto, you do not report every bruise and scrape. That's not the burden. It would inundate the Industrial Commission. It would inundate doctors with little claims. It would be overly burdensome for employers to have to receive a claim every time someone received a paper cut or a small scratch or scrape. That would normally be nothing and not a problem. It's important to point out, too, that a scrape or a scratch or a bruise would not even be a compensable claim without some kind of loss. So without the infection, without the complication and the problem following the abrasion, scratch, or scrape, we wouldn't have even had a claim to file. I think it's analogous to forthwith reporting. Judge Swan, I think you mentioned manifest. The laws have been very consistent, stating that a reasonable person, when that person should have known or knew when an injury occurred, that's when the statute of limitations starts. That is when the injury becomes manifest. And in the forthwith reporting cases like Pacific Fruit and the statute of limitations cases like Mofford, that reasoning of when did the injury become manifest, that all comes into play, and I think it's very analogous to the reasoning here.
You know, there's something a little unsettling about this case, and it is that in thinking about this and what happened. In a sense, your client kind of back-ended into a determination as to what caused the scratch or the abrasion that led to the infection. Because he doesn't have, as I understand it, does not have any recollection as to a specific scratch on the 27th. So with hindsight analysis, he kind of back ends into March the 27th. You heard our discussion with counsel about the Valley fever cases. Do you have any cases what's your strongest case for justifying the compensability decision here? What's your very best case? Because this is kind of I think, a little bit of an unusual situation. Most of the cases we see on appeal, it's quite clear someone fell, something happened, there is a trauma, an event, and it's easy to determine that happened. This one is a lot more difficult because of the nature of the injury here, because it was so de minimis.
Your Honor, I think you touched on a couple of things in that question that I would like to address in the 15 minutes that I have. You asked me for the best case, so I guess I'll start with that and hope I remember the other items. But I think Breedler, it would be the best case. Breedler, and that was in the supplemental citation. If you look at that case, which dealt with Bell's palsy, where the claimant did not have Bell's palsy before, he was hit in the face with a cold draft, but he had it afterwards. And in that case, there was no one knew that the draft occurred, but he didn't have it before, and he had it after. And the doctor said that the cold draft hitting the side of the face was certainly a way that Bell's palsy could be incurred. Breedler says the sequence of events, so the timing, plus medical proof of possible causal relation may amount to proof of probable causal relation in the absence of evidence of any equally probable cause. And it's important to note that in reviewing the evidence before the judge, there really wasn't any other evidence available to her for other causes of the injury. He backed into it because that was how it happened. He didn't even know when he had the malaise and the flu-like symptoms. He did not know that he had an infection, even at that time. He called into work. He said, "I'm sick. I had the flu." He didn't call in and say, "I had a work injury," because he didn't know he had an infection at that time. It wasn't until April 4th when he notices the redness, the dime-sized wound, the swelling, and he goes to the doctor, and the doctor says, "You have an infection." That's when Mr. Ketterling, the light bulb went off.
So why identify the 27th as the specific date?
Because that was the day he worked. And it should not matter. We go down to the Industrial Commission and there's examples, okay? Let's look at the person that works the night shift from 10 p.m. to 6 a.m. Do we really care that the injury occurs at 11:59 on a Thursday or at 12:01 on a Friday? The judges, they don't care. You pick one. And what matters is that the injury occurs at work. You look at a back injury, very common. Guy is moving boxes for several hours. One of those boxes is the one that is the straw that broke the camel's back, and that's the one where the disc herniates. But all the boxes leading up to it may have been contributing to that. We don't care if it's box A, B, C, D, E, or F. The fact is that there was a work activity that contributed to or caused the injury. That's what Mr. Ketterling needed to show by preponderance of the evidence. And it's not a burden of positive proof, and he did provide more than some evidence. I think it was actually the only, at least testimonial evidence, that the judge had to make the conclusion that he had sustained his burden of proof.
Counsel, so if we
Yes.
go back to my question for opposing counsel.
Okay.
Dr. Pham establishes at most a 10-day window during which the scratch and the infection, the initiation, if you will, of the infection would have occurred, correct? 10 days.
A 10-day incubation period.
I'm sorry?
A 10-day incubation period, sure.
The incubation period.
Okay.
I believe Judge Norris referred to it as gestation period. But
Sure.
An incubation period. 10 days. My understanding is that Mr. Kettering was asked during that 10-day period, what is the total universe of possibilities of your getting scratched during that period of time? And he said,
golf, my girlfriend, going to school part-time, and going to work. And then on page 38 of the transcript, he said that the only place that he could have sustained the scratch was at work.
point being, he laid out what he'd done during that 10-day interval, correct?
Correct.
And ultimately said none of these other things come to play. From his experience, he received scratches at work. He didn't receive scratches from these other places, had no recollection of it. Hence, work was the circumstance by which it began.
Correct.
Thank you.
Correct. I'm not arguing that Mr. Ketterling knew that he sustained the scratch at a particular moment, on a particular second, at a particular location on March 27th. I think he admitted that he did not know that. And I'm not arguing that he could have, that there's no other realm of possibility that a scratch can occur anywhere. But what we look at is what the burden of proof is, which is more probably than not by a preponderance of the evidence, and the judge making the reasonable warranted inferences that she needed to make in order to resolve the conflicts. She found Mr. Ketterling to be credible, and his testimony was corroborated by not only disinterested witnesses, but witnesses who were testifying against their own enlightened self-interest because they were still employees of the company. And that cannot be ignored. If you look at the medical testimony, the doctors are always given the history of how an injury occurred. Unless the doctor was standing over the claimant when the injury has occurred, he has to be provided with the facts of the case. Doctors are not fact witnesses, they're medical witnesses. They have to rely on the veracity of the claimant, or at least the correctness of the hypothetical that's provided. And the only evidence that the doctors can provide would be findings on examination or medical conclusions. If the doctor had found that he had a pre-existing infection, that would be a reason to rule against him, that certainly the doctors could have testified about. But again, that Breedler principle is instructive, where the sequence of events plus medical proof of possible causal relation may amount to proof of probable causal relation in the absence of evidence of any other equally probable cause. The judge gets paid to make these credibility determinations, make warranted inferences, resolve conflicts in the medical evidence. That's Malinsky. It was within the incubation period. He wore shorts to work. The two other merchandisers testified that they also would sustain these scratches, and it was not a big deal. They'd go home, wipe off the dried blood, no problem. They didn't report them. The recruiter said he wouldn't expect them to report these scratches unless they thought they needed medical attention. This court has a very long history of deferring to the trier of fact unless the administrative law judge's resolution of the conflicts are wholly unreasonable. And I looked for it. I could not find it in any of petitioner's arguments in the opening brief, request for review, or reply brief, or even in oral argument. They never said Judge Nye's resolution was wholly unreasonable. Judge Norris, you touched on valley fever, and I don't know how much you guys are considering that. I think those cases are completely distinguishable. Mr. Ketterling does not have to show a statistical or mathematical proof that the injury occurred more likely at work than anywhere else. That's not his burden. The valley fever cases, if you look at them, almost ensure that no one's going to have a compensable valley fever case in the valley, because the valley fever spores are everywhere. You get it by the involuntary act of breathing, and that's not how you get a scrape. You have to have some kind of assault to your anatomy that you do not have in valley fever, that you do need in order to have the infection. You need that microscopic or some kind of abrasion, scratch, break in the skin to allow the infection to enter. In the O'Connor case, that petitioners cite, The entire geographic area of the claimant's work, home, shopping, everything was all within the area where valley fever was, and there was no way to distinguish whether he breathed in the spores at home or if he breathed them in at work. Here we have very clear testimony from Mr. Ketterling that he would be in the back storerooms of these grocery stores with product that he had no control over where the product was placed. Evidence showed that, sure, some of the aisles were wide, but some were constricted. He had to shimmy around these cardboard boxes, which both doctors agreed were sufficient to break the skin, allowing infection to set in. Those back storerooms are not places where the normal commonalty, if we want to talk about the Treadway test, it would be in. The customers at the grocery stores are kept out of the back storerooms. They put those big double doors so we don't go in there. And that is where Mr. Ketterling would work, down stacking the pallets and constantly working with these beer cases and cardboard, which even Dr. Kelly says would be sufficient to cause a break in the skin. I have just a few minutes left, and I would just like to leave you with these thoughts that the burden of proof at the Industrial Commission, it's preponderance of the evidence. It's more likely than not, more probably than not. It's not 100% proof. It's not proof positive. The judges, they have a duty to identify the conflicts and resolve those conflicts, and that's exactly what Judge Nye did. The ruling on credibility, finding Mr. Ketterling to be a credible witness, that was within the exclusive province of Judge Nye. She found him to be credible. And Mr. Ketterling was honest in saying that he could not remember the exact second where he was standing, exactly what he was doing when he received that particular scratch that became infected. But it shouldn't matter if the scratch was one of the three. Was it the number 1, number 2, number 3 that he sustained that day? It shouldn't matter if it happened on March 26th or March 27th, as long as it made sense and he met his burden in the eyes of Judge Nye, and that he did. With regard to the judge's resolution of the conflicts and her inferences, which were reasonable and warranted and supported by the facts, her decisions must be upheld unless they are wholly unreasonable, and that was never claimed because they were not wholly unreasonable. The petitioners have never said that. They were for that very reason, and the burden of proof was met by Mr. Ketterling, and we ask that Judge Nye's decision be affirmed. Thank you.
Thank you very much. Thanks to both counsel for your arguments. We'll take this matter under advisement and issue a written ruling in due course. We now stand adjourned.
Hi, this is Chuck. Hi, Chuck.
He goes,
Yeah,
does she look
squad.
like you? I said, yeah, you'll see.
You too. Yes.
All the doctors and lawyers in the
Is my
family.
face all hot?
You
You did great.
you were good.
You could have just, you just could have just thrown water on my burning body before you had got up there and talked, though.
Well, they look, I was like, should I stop now? Because they weren't even looking at me.
No, you really don't have to do the full 20.
Yeah.
I've seen people who've
Could
done
have just
like
run over
10.
with a pitcher of water. And I said, have a great trip. Careful.
Thank you. I know we're flying. 4 hours. Yeah. Introduce your fiance to the family.
For who?
My fiance. I'm engaged. You didn't know.
No.
We're getting married. Where have you been?
Thanks a lot for showing us.
She didn't get permission from the other members.
I know. Roger still wants to put it to a vote.
Congratulations.
Thank you.
That's cool. Nice to meet you.
You too, Chuck. All right. Scott Houston's like, I didn't know that. Man, I'm just sitting here calling Steve and not doing.
You know, Richard likes to micromanage. I'm not sure. I'm not sure this has happened.
He wanted to be a bridesmaid.
And so I have this one file here, and I don't know if I stop this file, if it's still gonna save this file. So this is the first 8 minutes, and this is still going. Then I'll tell you what happened. So we need to somehow splice those